Is this new USCIS memo going to target your green card application? Last week, USCIS dropped a bombshell memo, and it changed how every green card in the US is going to be decided going forward. This doesn't just affect new cases, it affects every pending I-485 with USCIS as of right now, including those filed years ago. So the question that every immigrant is asking is, does this apply to me? My name is Moumita Rahman. I've been an immigration attorney for the past 16 years. I've spent the past week breaking down exactly what this memo means. So in this video, I'm going to show you who the memo is targeting, how big the risk is for your case, and what you should do right now to protect yourself. Okay, so now who does this memo target? Not everyone is in the same boat here. Some case types are in real danger, others are barely touched. I'm going to rank the main groups for you, starting with who's at most risk and working down to who is the safest. But before I do, I want you to hear one thing, because the panic out there is real. This is not the end of green cards. Approving a green card through adjustment to status has always been a matter of discretion. This part is not new. But what has changed is that some of you may now need to work harder to prove why you deserve a green card. So as I go through these groups, don't panic. Just figure out where you stand and prepare your application accordingly. So let me start at the top with the single highest risk group. If you came here on a tourist visa, met someone, married a US citizen, and now you are trying to get your green card without leaving, this memo was written for you. The whole idea behind a tourist visa is that you leave once you're done visiting the US. This is the promise that you essentially make when you get let in. So when you stay to get your green card instead, USCIS now treats you as breaking that promise. And this memo tells the officer to hold the breaking of the promise against you. So if you have overstayed your visa, USCIS will count it as a second mark against you. Now, this next group is also at high risk because they made the same promise to leave, but just on a different visa. And this visa is people on student visas, your F1, including those of you on OPT or STEM OPT, plus TN visas for Canadians or Mexicans, E3 visas for Australians, J1, E2, and O1 visas. Every one of these is a single intent visa. This means that the government gave you this visa on the condition that you would leave once you were done with the purpose of the visa. So now, when you try to get your green card from one of these visas, USCIS can treat that as you going back on your work. For students especially, I want to be clear about one thing. For years, there has always been a pathway that most people have followed. Study on your F1, work on OPT, win the H-1B lottery, then get your green card. That path is not gone. But filing for a green card application while you are on your F1 and on OPT before you have reached the H-1B stage is more dangerous now than it would have been a month ago. Now, the next group is at risk as well, but a little bit less because they made a different promise when they came. If you came here on an H-1B or an L-1B visa, you're a little bit safer because you are on a dual intent visa. When Congress created them, they wrote right into the law that you can work here temporarily and hope to stay permanently at the same time. You never actually promised to leave, so you're not technically breaking any rules. And the memo actually does say this. It says that applying for your green card on H-1B or L-1 is not inherently inconsistent. And that is the best language for any group that I'm covering in this video. And it also applies to your spouse and kids on H-4 or L-2 as well. But don't get too comfortable because the memo does add one thing. It says that being on a dual intent visa is not enough to get you approved. So you are starting in a better position than everyone that I've mentioned so far. You are not automatically immune. You still have to prove that your case is worth approving. Now, this brings me to the moderate risk groups, the ones where the law is genuinely on your side, or at least it should be. Let's start with the K-1 fiancé visa. If you came on a K-1, married your US citizen sponsor within the 90 days required by the K-1 visa, and now you have filed your adjustment to status application with that same spouse, you should be in a good space. The K-1 was literally designed to get you here so that you can get married and file an adjustment of status and stay. This is the whole point of it, and even the memo acknowledges this. And also, spouses, children, and parents of US citizens are also still at moderate risk. Even though you might be considered an immediate relative, this memo still requires for you to prove why you should be granted adjustment to status. If you have overstayed your visa, then you're going to be at risk. And anything more serious in your file, like fraud, an old removable removal order or criminal history can count as a negative mark against you. Now, for those of you getting your green card through a business type visa, such as an EB-5, EB-1, or an EB-2 with national interest waiver, you might have some reassurance here because USCIS has said that persons with economic merit would likely be able to continue on their current path. And that makes sense because the more your work or your investment benefits the United States, the stronger your case is going to look and the more of a positive equity your case is going to have. But still, make sure you don't treat it as a guarantee because officers are not promising anything in writing. Okay, now let me get to a group that many of you are waiting for. And this is where the news is actually good. If you are filing underneath VAWA, a T visa, a U visa, a special immigrant juvenile status, or asylum, this memo does not apply to you. And here's why. This memo is built entirely around one idea, that it applies to people who came here temporarily but did not leave when that temporary status was finished. But for these humanitarian green cards, the way that you get your status does not have to do with anything about how you entered the United States. It is instead based upon what you went through. So this memo is not really built around your case type. That being said, you still want to stack the deck with evidence of your positive equities no matter what. You want to show that you have good moral character. But there's one more thing. If your green card adjustment of status application is built upon you being a refugee or an asylee, your path is not discretionary at all. Congress wrote this directly into the law. If you meet the requirements, USCIS must approve you, and an officer does not get to weigh whether you deserve this. Refugees are facing other obstacles to getting approved right now, but this memo should not affect any adjustment of status applications for them. Finally, if you already have your green card, you can relax. This memo applies to people applying to get their green card for the first time. If you are already past that step, whether it's a 10-year green card or a 2-year green card, you should relax because this memo does not apply to you. It also does not apply to anyone applying for naturalization. Renewing your green card, removing conditions, or applying for naturalization are completely separate processes that this memo does not affect. Now, let me show you what to do to prepare your case to take into account this memorandum. First, one thing that applies to everyone being targeted by this memo. It is not just for new applications. USCIS has confirmed that it applies to every pending I-485, no matter how long the I-485 itself has been pending. So whether you filed a year ago or 5 years ago, if you're in one of those high-risk categories, then you need to take this memo into account. So keep in mind that this is not something to wait on and see. So let's start with the highest risk group. If you came in on a tourist visa and married a U.S. citizen, here's what you should do. Number one, don't leave the country trying to fix your application without talking to a lawyer first. Leaving the country can trigger a 3 or a 10-year bar, and you could be stuck outside for years. Number two, get your case filed, but work with an attorney who's going to take these factors into account when they file your case. This is not the time to file for your own and hope for the best. A good attorney will run through your history, find the problems, and attempt to resolve them or to address them before USCIS calls them out first. Number three, give them all the positive evidence that you can. I'm talking about proof that your marriage is real, your tax records, U.S. citizen children born in the U.S., property that is owned, community ties, and letters from people who can attest to your good moral character. Anything that shows that your life is here and that you are a good person who is worth approving will help your case. You want to make this argument upfront before they ever ask. And have your attorneys preserve your case for appeal just in case it does not go your way the first time. Number four, the most important one, be upfront with your attorney about your entire case history. Talk about things like your old social media, what you told your officer when you applied for the tourist visa, as well as what you told the officer when you came into the United States, and about any work that you did without authorization. Because the worst thing is that you can try to hide something and that will make you look like you are intentionally trying to defraud the government. Hidden facts are what can turn a denial into a fraud finding. Now, if you are on a single intent visa like an F1, TN, E3, J1, E2, or O1, then your move is going to be different. If you have any other option, don't rush to file your green card from that visa right now. For students on F1 or OPT, that usually means you might want to wait until you have reached the H-1B stage where it is dual intent. And if you are any one of the others, ask your attorney whether moving to an H-1B makes more sense for you. That one change can be the difference between an approval and a denial. And whatever you do, don't leave the country without talking to your attorneys first. Now, if you are on an H-1B or an L-1, your job is to not get complacent. Don't just sit on a pending green card application and assume everything will be fine. fine. Still make sure that you put together your own positive equities package with the evidence that I mentioned earlier, including your tax records, evidence of your community ties, and a letter from your employer or other witnesses backing you up. The employer letter matters here more than it used to. It is not just a formality anymore. It is part of showing that you are still worth approving. And if you are on an L1 and getting close to your time limit, ask your attorney about moving to an H1B now while you still have time. Next, if you are in one of the moderate risk groups like a K1 or an immediate relative who has filed, your advice is more simple. File while your case is strong because we don't know what is coming next, and getting in line still protects you. So don't go bare bones just because you feel like your case is clean. I see people do this all the time. They think my case is simple, I don't need to send much, I don't even need to work with an attorney, but a thin file gives room for more questions. So send your positive evidence up front and make their decision easy. And for employment cases, build your case around specific contributions, your achievements, the jobs you've created, and the value that you bring to this country. That is exactly what is going to make an officer want to approve you. Next, if you are in one of the groups the memo does not apply to, such as a VAWA, a T visa, a U visa, refugees, asylees, or special immigrant juveniles, keep going. File your case as normal, but still make sure to address any negative factors that you can. Even though the memo is not really about you, you still want to compare it in case the officer brings it up. And work with an attorney because these are still technical cases, and a small mistake can cost you. And finally, just remember that this memo is trying to scare everyone out of filing and trying to force people out of the United States. That's the point of it, scare you. So don't let it work on you. If you have a lawful pathway to a green card, that pathway is still there no matter what any silly old memo says. The law is still the law. You just have to be smart and know what it is. My name is Moumita Rahman, and I have been practicing immigration law for the past 16 years. If you would like my help on your case, you can give us a call at 212-248-7907. We are based in New York City, but we work with clients all over the United States. Now, getting your green card approved is just one fight. Keeping it is a completely different game. Right now, USCIS is watching green card holders pretend specific mistakes, and most people don't even realize they're making one of them until it is too late. I'm talking about things that can put you into removal proceedings or even get your green card revoked. I break all of them down in my other video, 10 green card mistakes USCIS is watching for right now. It's already been seen by more than 200,000 people, so you don't want to miss it. I'll include a link here. Click next and I'll see you there.